Well, welcome back. And it's been a while since we've had Jim Burling with us. So appreciate this man and their organization. He's with the Pacific Legal Foundation. He's Vice President of Legal Affairs and the author of a fascinating book, Nowhere to Live, The Hidden Story of America's Housing Crises. And there's a picture of the cover of that book. It's a passion of his. And I think if you want to know where homeownership is going, take a look at this book. And it's called The Hidden Story, Nowhere to Live, The Hidden Story of America's Housing Crisis. It has a website, pacificlegal.org. Pacificlegal.org. They're there working in your behalf. Check it out. Check out the cases that they're following. They're Supreme Court hawks, to say the least, and support them. Pacificlegal.org. Jim, good to see you, friend. How you been, buddy?
Hey, it's been great. It's good to see you, too. I have been well.
Well, you're a busy guy. All right, so we're coming up to the end of the term, and you guys, you're in a constant orbit over the Supreme Court. Hi, any surprises this go around?
Not surprises, kind of affirmations of what we suspected was going to happen, say with the tariff case. The tariff case was very questionable from a constitutional and statutory ground. And the Supreme Court struck down those tariffs in a rather decisive decision. There were 3 dissenters from the conservative side. President Trump was very unhappy. But I think it was rather an unsurprising decision because the way that the law read and the way the Constitution read. We've also had some very interesting oral arguments on birthright citizenship, and recently a fascinating case on the question of whether or not we can, I'm talking about the affirmation of a therapist's ability in Colorado to guide somebody to maintain their own sexual identity. The Supreme Court upheld a right of a counselor to help somebody affirm their existing sexuality, gender.
All right, so let's unpack those. Let's go to the tariff. It was a ruling against the president. However, he's found a way around that, and there doesn't seem to be any consequences.
Well, there will be some consequences because the way he has found around that is a temporary ability to impose tariffs for 6 months at a maximum of 15%, rather than the every week, every day seem to have a new tariff at great higher levels and for an indefinite period of time. So his authority to impose tariffs has been constrained. And now there's going to be a tremendous amount of litigation about refunds of tariffs that are already paid, who is entitled to those refunds, if any. So there are some questions yet to be had. But the president's power on tariffs was constrained as it is in the Constitution.
During the Biden administration, he was told not to forgive student loans, and he did it anyway, and there was no consequence there. So what is the power of some of these decisions?
Again, with President Biden's forgiveness, he did find a different way. And the thing is, it's sort of like a whack-a-mole, that an unconstitutional act is done in one way, such as with the Biden student loan, and he found another provision to have a lesser forgiveness for fewer people with student loans, which is in turn is turned down. I think the lesson here is that when you're dealing with a president, Republican or Democrat, that wants to do things outside the authority that he or she may have and outside the authority of the Constitution, it requires constant vigilance. One lawsuit after another, and eventually you can put that whack-a-mole back into the ground and have the Constitution restored. But it's not an easy process. It's something that you keep on having to fight for, and I think it's a fight worth having for our constitutional rights and liberties.
I want to come to the Colorado case where the therapist was allowed to do the transition counseling. This is amazing. This is a huge win for that issue, and it's a huge win for therapy in general.
Yeah.
What do you think about that?
Oh, I think it's a very big win on First Amendment grounds. The right to express yourself, the right not to have government speech. I mean, we've had a series of cases in the recent years where very liberal and aggressive governments have tried to regulate or even force speech. There was a case out of California which was cited repeatedly in this opinion where pregnancy crisis centers were required to read from a script to tell the young women coming into their centers that you have a right to get an abortion. You can go down the street and get an abortion, and you should seriously think about it. And that was totally an anathema to the religious and First Amendment rights of the people that were running the pregnancy centers. They were running the pregnancy centers to help young women have their children, have their babies, not to advise women about getting abortions. And the Supreme Court rather decisively struck that down. And this case out of Colorado is really an extension of that, where therapists were told, look, if you're going to do talk therapy, you can do all the talk therapy you want in order to affirm somebody's decision to change their gender. But if you want to have talk therapy with somebody to affirm their decision to maintain their existing gender, to not go through a transition, that's illegal. You had an 8-1 decision from the Supreme Court with all the liberals, except Justice Jackson, joining the opinion saying that, no, this is a violation of the First Amendment rights because you're not only telling somebody what you can say or not to say, you're telling them exactly what you can't say, but you can say this. So essentially, you're becoming a government mouthpiece for government speech, the favored government speech of the state of Colorado. As you know, Colorado has been very aggressive in imposing its vision of gender rights and gay rights on people. The Cake Baker case came out of Colorado. And here's another one. And I think the Supreme Court is going to continue to strike this down because people have liberty to say what they want to say, even in the setting of a therapy session. Justice Jackson, in the dissent, was saying, no, we're not regulating your speech. We're regulating your conduct as a therapist. And the Supreme Court majority, including the two liberal who concurred in the opinion, said, no, you're not just regulating a profession, telling somebody how much aspirin you can prescribe to a certain condition or what kind of surgery you can do. You're actually telling them that they can only engage in this kind of speech. It's not regulating conduct, it's regulating speech. And that you cannot do.
This is huge. I mean, it's deregulating licensed professionals. I mean, this is really big. I mean, no longer, and they just got deregulated on what they can and can't say in a therapy session. This is a huge win.
Yeah, I mean, the very idea that you're having a one-on-one therapy session with a person coming in this case, young people coming in who are very conflicted. You hear so many things in this world coming at you about gender and equality and all these kind of things that are carries a great deal of conflict in somebody's mind, especially if that person has any religious background and religious values. What am I hearing? All these people saying that I should change my gender.
Right.
I'm confused, but what do I really want to do? The therapist was not allowed to say, go with your gut. If you want to maintain your current gender identity, I'm going to help talk you through how to do that. And the best way is to feel comfortable in your existing skin, in your existing genetics.
Right.
So that was unlawful. And I think it's huge. Now, therapists, you have certain things you can't do. You can't do certain surgeries. You can't prescribe certain medications in certain circumstances. But the ability to talk through one way or the other with your client, that's important because look, I'm a lawyer and I like having confidential conversations with my clients. I don't want anybody telling me what kind of legal advice I should be giving as long as it's competent. I mean, if I'm going to encourage somebody to sue the government, I shouldn't have anybody tell me I can't do that.
That's amazing. Does this get real close to what is said in a confessional?
I think it has a very close relationship. I mean, in a confessional, you're bringing a lot more of religious liberty into the issue rather than simply a First Amendment issue. Mm-hmm. But you have to remember the therapist, in this case out of Colorado, was very religiously motivated herself. And so when somebody is in a confessional and they're telling their priest or their minister or the equivalent, look, I have done some bad things. I want to I want to be right with this. Uh, the priest has generally had the right to keep that confidential. I, the only exceptions are if there's an imminent threat or danger. If somebody says that I'm going to go out and kill somebody and I have the gun to do it, and I'm telling you in advance, but you're not going to stop me. I just want you to know I'm doing it, and maybe I can get forgiveness later.
Right, yeah.
There might be a requirement to protect somebody's life to say, hey, John Smith is going to try to kill you today and report that. But beyond those narrow exceptions,
Yeah.
what should go on in the confessional should be between the minister or the priest and the person going in who wants to, hear God's word and how should I behave in certain circumstances if I've done something wrong.
Yeah, good said. All right, let me take a quick break. Let me say our viewers and listeners a couple of things. Check out Jim's book. I think we'll briefly talk about that, but it's a must-read when it comes to property rights. Now, Nowhere to Live, The Hidden Story of Americans' Housing Crises. And then, of course, the website for the Pacific Legal Foundation is pacificlegal.org, and there's a picture of that landing page. We'll be right back. Okay, welcome back. Honored to have back with us Jim Burling. He's the Pacific Legal Foundation Vice President of Legal Affairs, and his personal book that is a fascinating read, Nowhere to Live, The Hidden Story of America's Housing Crises. We're talking about the Supreme Court and some of the rulings. By the way, they have a website, pacificlegal.org. Jim, I want to get into the birthright citizenship arguments that we all listened into. It's obvious that the 14th Amendment is being abused, but it's also obvious in what it says. And I think we now have reached a kind of a catch-22 situation, so to speak. It needs to be fixed, but it does says what it says. The president attended that first time in the history of the United States where the president sit there and listen to the oral arguments. I listened in and out, and I walked away thinking that the court doesn't seem to be convinced. What's your take?
I agree. I don't think the court was convinced by the United States' or the president's arguments. Attorney General Sauer was trying his best. But I think the court was looking at the literal text of the Citizenship Clause, which says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So that you have to unpack that, and there are a few questions. So when it says subject to the jurisdiction thereof, does that mean a person who is living in the United States, whether they're here illegally or otherwise, are subject to our laws? The answer is yes, we're all subject to our laws. But the Attorney General was arguing, no, more is required. You have to actually be domiciled in the United States, which requires you to have allegiance to the United States. And if you're here illegally, do you have allegiance to the United States, or do you have allegiance to the country where you came from? Now, this was a big deal and a big issue back in the after the Civil War, because as you know, the Dred Scott decision held that African Americans were not citizens of the United States. So this clause was passed to make sure they were. But a question came up as to what about those slaves that were imported here illegally after importation of slaves was made illegal in the early 1800s? There was a period of time between the time the Constitution was adopted and 1808 when the importation of slaves was lawful, but it became unlawful. So what happens if a slave was brought here unlawfully? Would that person's children be citizens or not? And so the consensus was that the 14th Amendment, the way it was passed, that slaves, children of slaves brought here illegally, were citizens. And then the question arose for Indians, children of Indians. And Indians had their allegiance to the tribes rather than the United States. Indians were not citizens and were not made citizens until Congress passed a law saying that they would be citizens. So we have the question of people that are here with illegal immigration. There was not such a thing as illegal immigration when the 14th Amendment was adopted. People were here legally or illegally, with the only exception being slaves brought here illegally. And so, looking at today, what do we think about this question of people who are come here illegally? Are they subject to the jurisdiction as the plain meaning of the 14th Amendment, or is it a much more refined or narrow reading, as the United States, Justice Sauer, and President Trump are arguing? So there were lots of questions back and forth on this. And I think overall, the court, including some of the more of the conservatives, Justices Gorsuch and Barrett particularly, had really tough questions. And I think they are very skeptical of the president's arguments. You take those two, plus the three liberals, you have five, that's a majority. And reading others such as Alito and Roberts, I think that they are on the fence, but I would be surprised if they ruled in favor of the president. I think the president is not going to win this case.
Okay, it didn't sound like it to me. I mean, I'm no lawyer, but, you know, listening to back and forth, it doesn't sound like the court was leaning towards that. So let's just assume for a moment the 14th Amendment stays the way it is. How do we deal with the abuse of the 14th Amendment? Do we go through Congress and change it? Do we do a constitutional amendment? What do we do?
So you could do a constitutional amendment, but as a matter of politics, I think that's improbable. It's really hard to amend the Constitution, especially when there is a very wide divergence of opinion on such an amendment. It's not like everybody agrees, hey, we should give women the vote. Of course, let's go ahead and do it. It's a much more controversial issue. So I think there's going to have to be, if you're going to deal with the abuse, the birth tourism, as it's called, where people come into this country solely for the purpose of having children. There are agencies in China. There are 500 businesses at least engaged in the business of helping bring Chinese women over to the United States to have their children so they could have a United States passport at some point in time, and a United States citizenship. I mean, God bless them. If I were living in any other part of the world, I would certainly want to have my children be citizens of the United States. For all the criticism we have, we are a pretty darn great country. But there is abuse going on with this birth tourism. So perhaps you could do more to crack down on that, crack down on the businesses, crack down on people that rent the homes for the purpose of the birth tourism. Perhaps have penalties against the mother saying, look, your child may be a citizen, you're not, you're leaving, you might want to take your child with you, and you, mother, are not coming back. So, you know, I think we've done a lot on immigration to make it much less attractive. And I think with some creative legislation, you can do things to make birth tourism more risky and more subject to discouragement.
Quickly, tell us about your book and why you wrote this, because I know you have a real passion for this.
So I wrote this book because after over 40 years of representing landowners trying to use their land to build homes, among other things, it became clear that the incredible difficulty that we have in this country to build new homes because of environmental regulations, because of lawsuits by those who believe not in my backyard types, the NIMBYs, by zoning that just makes it impossible to build starter homes in most of the country right now. Because it's so difficult to build homes, the supply of homes is going down tremendously compared to our population. In the 1970s, before all this environmental and zoning laws hit the way they've hit recently, we used to build a lot more homes than we are today.
Right.
We had 130 million fewer people. So that's why I wrote the book, to try to explain to people the reforms that we need to take in order to undo the housing crisis that we have now, which is bottom line, we got to build more homes.
All right, check it out. Nowhere to Live, The Hidden Story of American Housing Crisis. If you're in the middle of this, or you're a developer, or even if you are a regulator, read this book, Nowhere to Live, The Hidden Story of American Housing Crisis. You can get that online, Amazon?
Amazon.com.
All right. And then pacificlegal.org, that's Jim's website. Good to see you, Jim. Let's stay connected. It's been a while. Let's, I guess in June, we'll see where all these decisions will be, huh?
That's right. We will.
Okay, buddy. Good to see you. God bless.
Okay. Good to see you. God bless.